I will now call the next case on the docket, 119492, State of Kansas versus Efron Gonzalez Jr. Counsel, come in, please.
Good morning. May it please the court. I'm Jonathan Lawrence for Appellant Efron Gonzalez Jr. And Chief Justice, may I please reserve 5 minutes for rebuttal?
5 minutes is reserved.
Thank you. On November 27, 2016, a young man named Filiberto Espinosa shot and killed Louis Scherzer while Mr. Scherzer was standing outside the Chicago bar on Central Avenue in Kansas City, Kansas. It was a senseless killing. Espinosa fired at Scherzer from the passenger seat of my client's car after my client pulled alongside Scherzer and engaged him in a conversation. Espinosa pled guilty and received a life sentence. My client was tried in Wyandotte County, and he was convicted of felony murder, with the underlying felony being an attempted aggravated robbery, and he was convicted of conspiracy to commit aggravated robbery. There was also a jury instruction concerning aiding and abetting an aggravated robbery. The issues that I hope to discuss with you all today are whether there was sufficient evidence of the attempted aggravated robbery, whether there was sufficient evidence of the conspiracy. Most importantly, was my client's Sixth Amendment right to compulsory process of a witness frustrated by a sham invocation by that witness and his lawyer of a Fifth Amendment privilege that had already been waived. We also need to briefly discuss a jury selection issue, which deals with race, and we have to, if time allows, discuss the appropriateness of a jury instruction tied to the aiding and abetting. I hope it did not escape anybody's attention on the court that the overt act charged in jury instructions 15 and 12 dealing with the attempted aggravated robbery, which is the felony underneath the felony murder charge, alleged that the state would prove beyond a reasonable doubt that my client held the gun and aimed it at Mr. Scherzer, which of course would have to happen before Espinosa had the gun and killed Scherzer. Espinosa's guilty plea and Espinosa's sentence eradicates that possibility. More importantly, there was no testimony at trial that my client held that gun and never pointed it at Mr. Scherzer. There is a grainy videotape of the incident, and in the videotape, you're not able to see that my client ever held the gun or gave the gun to Mr. Espinosa. Likewise, I submit that there's no evidence of the conspiracy. The issue which I would like to address next is this idea that Mr. Espinosa had a right to take a Fifth Amendment privilege and raise that at trial. Now, first of all, Mr. Espinosa...
Counsel, before you continue on that issue, you just said there is no evidence of a conspiracy. Wasn't some of the evidence about text messages?
Sure.
And a reference to getting paper?
Okay, so the text message was only a few words long. It was, the first word was T-A-N-N-A. Mm-hmm. Let's presume that it was a misspelled for wanna instead of tana, like okay. Slang for want to.
Yeah.
Wanna get that paper. Mm-hmm. That doesn't talk about a time, a place, an agreement.
Wasn't this in response to a girlfriend who wanted him to come home, though?
Right.
So kind of in the nature of this is why I can't come home now?
Just says, I want to get that paper.
Right.
Now,
I understand that's the direct evidence, but you're well aware, given your experience, that people can be convicted of the most serious crimes on circumstantial evidence. Isn't that some circumstantial evidence that he had an intention to go do a robbery, given the detective's testimony about what paper refers to?
I would submit that if anyone was to suggest that the text message was sufficient to support this conviction, that's about as thin as a piece of paper. And the reason being, it doesn't say who, it doesn't say when, where. There's absolutely no evidence of any agreement, and you have to take it in peri materia.
There's another text message about him being a teammate in the
Teammate's
roughly
grip.
the same time
Right.
frame,
In the same time frame.
which indicates he's cooperating with someone else, doesn't it? At least circumstantially.
Sure. But if we look at the videotape and the testimony, there was no evidence that any robbery was taking place. Sadly, when Mr. Scherzer, when his corpse was processed, he had his wallet on him. Nothing was missing from him. There's no sign on the videotape of any struggle. They don't grab Mr. Scherzer. They're in the car. Mr. Scherzer's on the sidewalk, approaches the car, and then the shooting starts. Mr. Scherzer hadn't even leaned in the car. There was no contact. There's no evidence, aside from this detective whose testimony unfortunately was unchallenged. The detective comes in and says, "Oh, Tana get that paper is slang for a robbery." I think we can all use our common sense. Want to get that paper can mean I'm going to go get a legitimate job, which I would admit at that time of night probably was not the intent, right? My client wasn't going to go to a all-night McDonald's and work around the clock. But the point being, that phrase does not mean I'm going to commit a robbery. Unfortunately, I've had federal drug cases where want to get that paper means I'm going to go sell some drugs. It has many varied meanings. And since we don't have any other corroborative evidence that any robbery was taking place, it is a long, far stretch to say that Tana get that paper means we're going to go rob somebody. Teammate's grip, again, that wasn't explained. Does that mean I'm going to drive my friend around? Does it mean I'm going to hold a gun for my friend?
What about the detective's testimony that there had been an admission by one of the two? Again, that wasn't, in fact, that was solicited by the defense counsel.
Yes.
And, you're trying to connect dots anytime you've got a case,
Right.
civil or criminal. And that's, a pretty good dot, seems to me.
Well, and I hope, and I understand and anticipated the court's confusion about that, and I've spoken with Mr. Obermeyer, and I think he's going to address it as well. Without using up too much of my time, what had happened there was defense counsel with limited federal experience had tried to work a deal for, and this is outside the record, but here's what had happened, had tried to work a deal for Mr. Gonzalez where Mr. Gonzalez would provide a proffer interview against Mr. Espinosa, and the understanding between the parties was that that would not be admissible. And
why does that matter? Because it was presented in front of the jury. It wasn't stricken. It's part of the record and the evidence that's here.
No details of the actual interview or statement were given at that point because the state, with its integrity, both prosecutors, Mr. Obermeyer and Ms. Tatum, immediately approached the bench and said, "Judge, this isn't supposed to come in." And then defense counsel went back to it, and his co-counsel had to come up and tell him to sit down. He had no clue what he was doing, but the point being, the sum and substance of the proffer interview never made it to the jury, never made it into the record. There's absolutely no context or details of any statement beyond the detective simply saying there was an admission by the defendant and didn't say what the actual contents of the admission were.
So do you have an ineffective assistance claim?
Well, that's primarily what my practice is, and I avoided making it here because there was not a record sufficient, right? One of the, our project.
You haven't moved for a Van Cleve remand on that point.
I'm sorry, I couldn't hear you.
I'm sorry, you haven't moved for a Van Cleve remand on that point.
No, I believe that an ineffective assistance claim should be developed post-conviction in its proper procedural framework, and that there should be a full evidentiary hearing and what have you. And my fear on asking for Van Cleve is that do you do it on one issue? Or are you better off doing it in the 1507 context where you're allowed to raise the myriad and full panoply of all ineffective issues? So I certainly hope that the fact that we did not stop that, or the fact that I did not, after the notice of appeal, ask for a remand for a single ineffective claim would somehow factor in, because procedurally he's entitled to 1507 proceedings.
Okay, counsel, I don't want to chew up any of your time, but you talk about this statement about the admission not having any context, and the transcript is pretty clear. Defense counsel says, do you have any evidence that Mr. Gonzalez said to Mr. Espinosa, I want his money? The detective says, yes, I have evidence. I mean, he says yes. And then the question is, and what evidence would that be? That evidence would be his admission. That evidence would be the fact that they discussed pointing out Mr. Scherzer, identifying, pinpointing a victim, targeting a victim for the robbery that they attempted to do when they murdered Mr. Scherzer. I mean, that's got all the context a jury needs to know, especially with the other evidence that's here, about what's going on in that alley. And so regardless of any background of that, that's in front of the jury. And that seems to be enough to connect the dots on these claims. So what am I missing?
Well, Your Honor, I believe that
Other than it might have been bad lawyering.
Horrible lawyering, if we're going to be candid, but at that point when the objection is raised by the state, which I believe they rightly did, right? I think that shows the integrity of the prosecution here. When that objection is made, and then co-counsel has to get up and stop this guy, what it deprives Mr. Gonzalez of is context, cross-examination. There's absolutely none of the traditional back and forth that you'd have on a debated fact in trial. The record's unable to be developed. I understand the detective's response, but now look at the Hobson's choice. For example, if competent counsel is in the room, how do you fix that, right? To get out the full context, when, where, how. And this dovetails right into the sham invocation by Espinosa's attorney of a Fifth Amendment right to avoid testifying in this trial after he'd already pled and been sentenced. With the court's permission, my time is certainly run out. I don't know how far into my rebuttal time I am, but unfortunately I've not had an opportunity to address any of the other three issues.
Are there questions of the court on any of these? Okay, thank you.
Madam Chief Justice, Counsel, may it please the Court, State of Kansas by Assistant District Attorney Wyandotte County Daniel Obermeyer. Your Honors, the case before the Court today is a textbook felony murder case. The State's evidence in this case, and if we're to follow in the closing arguments at least, it was largely uncontroverted evidence. The defendant's car was used, the defendant's gun was used, the defendant was in the driver's seat in the car when his co-defendant, Mr. Filiberto Espinosa, fired a shot, killing Louis Scherzer. And the evidence in this case showed that the two of them were working in a robbery. And specifically, the State's evidence, what the State drew attention to in closing arguments, was not whatever statement that Mr. Gonzalez had made in a proffer, but it was solely on the text messages and his actions in driving the car as evidence that he intended to commit this crime of aggravated robbery. And also, that same evidence, those text messages showed he was conspiring with Filiberto Espinosa to commit that crime of aggravated robbery. They merely failed in the attempt to do so. So,
how do you respond to defense counsel's argument that the state failed to prove the alleged overt act?
well, I think that the overt act in this case would be at some point a gun is drawn and you can
So you
circumstance.
disagree with defense counsel's characterization that the state limited itself to the overt act of the defendant pointing the gun. That's how I understood the argument.
Yes, but that's not legally required in jury instructions to have, we had a case, 2 cases yesterday where the instructions were explicitly saying the defendant or another for whose criminal liability the defendant is responsible. That language is not legally required under when the state pursues an aiding and abetting theory, and I think this court has said that, and I believe it's the Dupree case. I could be mistaken.
I'm just trying to clarify. You don't agree with what I understood defense counsel to say, which was that the state had limited itself.
No, I don't agree with that at all. The state didn't limit itself with those instructions because in felony murder, it makes no distinction as to if there's an aggravated robbery going on. There's no legal distinction as to who's holding the gun, who's asking for the money, who fires the shot.
But in conspiracy, you need to have the overt act.
Yes.
I think that's what my colleague's trying to get at. Your opposing counsel indicated that the instruction on the conspiracy was limited to an overt act designated by the state. And I think he's trying to ask you, is that in fact correct? And I think the 2 instructions were 12 and 15, counsel? If that helps you find it.
Okay. Yes. Well, I don't think that element there, because the element reads, it's element number 3 in jury instruction 11, the defendant or any party to the agreement acted in furtherance of the agreement by aiming a firearm at Louis Scherzer.
Your response is it doesn't matter. The state didn't charge that the defendant pointed the gun. It was that someone in the conspiracy pointed the
Yes,
gun.
or any party, but in that language, it's not specifically required for aiding and abetting theory, so I don't really see that as an issue, especially in felony murder context where we're talking about the strict liability, where the instructions clearly instruct the jury that Mr. Gonzalez has to intentionally be participating in an aggravated robbery.
Since we're on that point, let me tell you my confusion about what you've written in your brief, which was this whole reasonably foreseeable language that's in that instruction and how it doesn't confuse things because you've got a few specific intent crimes, plus you've got unintended crimes, and your argument is, well, that was only going to the unintended crimes, except it doesn't specify that in the instructions, and I was having trouble with understanding what your point is.
If I may, so jury instruction number 5 is the aiding and abetting instruction, and the complained of instruction, it says, quote, the person is also responsible for any other crime committed in carrying out or attempting to carry out the intended crime. If the person could reasonably foresee the other crime as a probable consequence of committing or attempting to commit the intended crime. And essentially that's the textbook definition of felony murder. This court has said that language is not necessary in a felony murder case. So clearly by the plain language of that complained of language in the instruction, it can't apply to felony murder because the felony murder count, it has no intent requirement. And so what
about the conspiracy?
The conspiracy...
You can't get tagged on specific intent, the attempted robbery, without having the same specific intent as your buddy.
I concur with that. And as I would say my first argument would be that, again, that language does not apply to the conspiracy because there is that specific intent language in the jury instruction 16. It says specifically the state must prove that the defendant intended to commit aggravated robbery, and that gives the definition of intentionally. And also, if you think about this logically, what's the logical progression of crimes in this case? Well, you would have first the conspiracy to commit an aggravated robbery. Then you would have the attempted aggravated robbery itself, and then finally that robbery goes wrong, and then you have felony murder. So if we're looking at reasonably foreseeable crimes here, really only the felony murder is reasonably foreseeable. It's not necessarily reasonably foreseeable for a conspiracy, but it is certainly reasonably foreseeable for a attempted aggravated robbery, And so logically, it really doesn't make any sense as to how that could apply to anything other than the felony murder, the reasonably foreseeable language. I would also note that in the aiding and abetting instruction, we have the standard, a person is criminally responsible for the crime if they intentionally aid another in committing the crime or advising another to commit a crime. And also we have the mere association instruction there as well. So the state additionally had to prove that just because Mr. Gonzalez is in that car, that doesn't necessarily mean that he is intending to commit that. We have to, he has to be something more than merely present. So I think that overall, the balance of these instructions are quite clear. And I would note that the prosecutor's entire argument was that Mr. Gonzalez acted intentionally. She says explicitly at one point that, and I'm paraphrasing here, but felony murder, this is a felony murder because there is no, he intended to commit this crime of aggravated robbery and it went bad. That was the gist of her argument. And she went in through all the ways that he intentionally aided Mr. Espinoza. He's the wheelman. It's his gun. He covers up the crime. He tries to hide the fact that a crime has happened here. When police, they meet him at the KU Medical Hospital, and they're asking him, hey, how were you shot? And he says, well, I was shot in Kansas City, Missouri. And he says something about him being on Central Avenue. Well, there's a Central Avenue in Wyandotte County. And then he says, is Wyandotte County coming? Well, why are you worrying whether or not Wyandotte County's coming when you're the victim of a crime? And then further, when he's in the Kansas police interrogation room, while police are preparing to interrogate him, he looks up at the camera and says, stitched lips, meaning he's not going to say anything, that he knows that he's guilty of something, but he's not going to tell him what it is. So really, there's overwhelming evidence in this case that he acted intentionally, not only to perform the aggravated robbery, but to cover it up. And also, if you read his text messages, it seems like he's bragging about it because he tells his ostensible girlfriend, in this case, to look at the news 7th and Central. And the evidence is that this bar where this murder happened is near 7th and Central. So there's overwhelming evidence that he is acting intentionally, that this isn't a mistake, that it's not mere association, that this is... So really, the reasonably foreseeable, it's not legally necessary, but it certainly doesn't hurt Mr. Gonzalez in this case. In fact, it adds an element that the state has to prove, that being that death is even reasonably foreseeable. That is an extra element that we had to prove in this case. I'll move on to... I believe the next issue in this case would be the multiplicity instruction. I don't think that, or the multiplicity issue. Essentially, this court has never held that the defendant contends that the overt act to support the attempted aggravated robbery and the conspiracy is the same, and that raises the multiplicity issue. And I would merely note that first, that fails the strict elements test that this court employs to decide whether or not counts are multiplicious in the first place, so it fails on that count. The next issue is the potential Batson issue. And in this case, the defense specifically challenged jurors 34, 39, and 44. It withdrew 35 because 35 is a white male. And he didn't really make a prima facie challenge if you read the transcript. He just says, it's our understanding that there were 5 Latinos, and it's not very clear. He says there were 1.5 Hispanics on the jury, and we are now down to 1 that made it to the jury selection process. If you look at the strikes made in this straight, I'd ask this court, which side is exercising strikes on an impermissible basis of race? Is it the side that struck 6 African Americans and 5 whites and 1 Hispanic? Or is it the side that struck 6 whites, 2 African Americans, 2 Hispanics, 1 Asian, and 1 person who identified as white, black, and Hispanic? Which side is exercising peremptory strikes for racial purposes in that case? And just so I'm clear, the defense is the side that struck 6 African Americans, 5 whites, and 1 Hispanic, and the state's the side that struck the other. The state struck more whites than the defense did. The state struck whites for the same stated reasons that it struck minority members in this case. And those reasons were basically age, length of employment, the fact that they're single or not married, and the prosecutor was clear she viewed that as investment in the community, and she struck whites for those similar stated reasons. There's really no inference that this court can raise that the state is trying to strike minority members. And I would note that ultimately the jury was composed of 1 Hispanic, 1 I believe half Hispanic, or 1 marked Hispanic and white on their jury questionnaire, 1 partial Native American, 4 African Americans, and 5 white jurors. So it was a very diverse jury in this case. The state could have used all its peremptory strikes to eliminate Hispanics, and it did not do that. And I'll rest on the brief for the stated reasons in that, but they're comparable reasons. And unless the court has any questions on that. The final issue is whether or not Judge Fairchild erred in disallowing the testimony of the co-defendant Filiberto Espinoza. And I think
Was there an understanding of the limitation of the testimony for Espinoza? It seemed to me that what they were trying to get was what was the behavior of Mr. Gonzalez that night. Did he ingest Xanax? Did he smoke marijuana? Did he consume alcohol? Those types of questions. Was that clear? I can't tell. Was that proffered? What was going to happen? What's the state of the testimony and the waiver of the Fifth Amendment? Where are we at with that? Was that clear as to what the intended testimony was going to be?
That's my first argument, that it's not preserved because it's not clear as to what precisely the testimony he was going to present was. And the state, in arguing this, says they basically want him to say that he saw Gonzalez smoke marijuana, take his Xanax, but they don't want to expose him to cross-examination. I think that's a fair assessment of what happened here. And the reason for their doing that was the whole defense argument was he couldn't or didn't share the intent to commit robbery, commit murder, all that.
The intoxication kind of
Yes.
defense in that regard to form and intent.
Yes. That's
If he's limited to that testimony, does that per se open him up to cross-examination about other parts of the crime? That's what the trial court kind of said was, this is going to open him up to all kinds of potential violations of his Fifth Amendment and may impact his. I think he had already been sentenced at this time, right, Mr. Espinoza?
Mr. Espinoza had been sentenced, and of course this court knows his appeal is pending before this.
Right, so it could affect his appeal rights, and so naturally you can invoke.
Yes, because he's hoping, and essentially, you know what the issue is, but for anyone watching for Mr. Espinoza's case, he's essentially arguing that his Hard 25 is unconstitutional under the Eighth Amendment, and part of that, there is a factual determination which has to be made. And so his counsel was of the opinion that this would potentially make it harder for him to argue that the Hard 25 is unconstitutional in his particular case, which is the reason why he didn't want Mr. Espinoza to testify. Okay. And to answer your question, I don't think that there is a meaningful way that they could have eliminated cross-examination on this point because, let's say Mr. Espinoza testifies, yes, I was with Mr. Gonzalez on that night, and I saw him smoking weed, and I saw him take a Xanax, and then the prosecutor has to get up and say, okay, and Mr. Espinosa, and what were you doing that night? Under what circumstances are you witnessing this? So, and even at one point on volume 5, page 564, counsel for Mr. Gonzalez, he says, and it's about middle page, I would ask the court about a ruling that we are going to limit the cross-examination to what the direct is. Reason being is that obviously if we open up cross-examination, then Ms. Tatum can ask any questions at all regarding the specifics of that night, and he would then obviously have a Fifth Amendment right if they were asking specifically what he did. So, Madam Chief Justice, I see I'm out of time. Unless there are any other questions, if I may briefly wrap up.
You may.
Thank you. The issues presented before this court do not present issues of reversibility. This case is a clear-cut felony murder case. Specifically, the jury instructions could not have possibly misled the jury into coming to an erroneous verdict in this case. I would ask the court to affirm the decision of the district court in various rulings and also affirm the verdict of the jury. Thank you.
You reserve 5 minutes.
Thank you. May it please the court. I'd like to pick up with this Espinosa issue. Let's talk about a couple of things. First of all, this absolutely was a sham invocation. All right,
Well,
Espinosa.
what's a sham about it?
Well,
If he opens himself up to cross-examination and his appeal is still pending, what is it?
Okay.
And typically, as you know, as a defense counsel who has represented people who have invoked that right in this phase of their appeal, that happens all the time.
And here's why, respectfully, improper analysis. First of all, the burden, let's dispense with everything defense counsel for Mr. Gonzalez was talking about. The burden on the invocation of the Fifth Amendment is on the witness who's asserting it. Klein Boone comes in there and says, oh, he's got an appeal pending. Here's why it's a sham. That appeal had nothing to do with his guilty plea. He wasn't appealing a trial verdict. He wasn't appealing a conviction. You folks are going to consider his appeal this coming Friday on a summary disposition calendar on the constitutionality of a statute. He's not trying to get out from under his conviction, and nothing in that appeal goes to whether or not he committed this shooting. It has to do with whether he's getting out from a mandatory minimum on a sentence. So they had the burden of persuasion to the district court, and they didn't carry it. That's the first part. The defendant had absolutely no burden to carry as to relevancy here. Here's why. Now, I know that the district court and the attorneys got off on some discussion about what Espinosa was going to be questioned about. Completely unnecessary. Mr. Franco could have asked Mr. Espinosa anything he wanted to on the stand. Here's why. Espinosa was the shooter. He's central to this case. There's not a relevancy hurdle that the defense counsel has to surmount when he compels somebody with a subpoena to appear at a trial. The person who has the burden is Espinosa's attorney to prove entitlement. Let's talk about the district court for a second. The district court skipped all that, and the district court said that the reason it was going to protect Espinosa's right to remain silent was because he had 1507 rights on the time clock. So let's talk about that for a second. We all know in Kansas, there's a presumptive 1-year time limit on a 1507, but we also know that really Kansas has no statute of limitations on a 1507 because Espinosa could get on the stand 3 years from now and say, I'm asserting my fifth. And the response would be, you're well past your 1 year on the 1507. And he could say, I have an indefinite amount of time to raise 1507 arguments about my actual innocence under the manifest injustice prong that has no time limit. So that's why it's a sham. The district court got it wrong. Espinosa should have been compelled to testify about anything Franco wanted to ask him. The fact that Franco was talking about Xanax and weed, that's for a different proceeding and a different day. But the bottom line is this. Espinosa could have been asked point blank, did Gonzalez ever touch the gun? Did Gonzalez and you conspire to rob this guy? Where we don't see any robbery taking place on the video. The bottom line is, Mr. Gonzalez's right to have a key witness in this case was thwarted from him. and a burden was imposed on his lawyer that didn't exist. The burden's on the witness invoking the Fifth. It's not on the person bringing him, and there is no relevancy hurdle. I'd like to talk briefly about the jury instruction. All I will say is this, that reasonably foreseeable language was ruled already by the Court of Appeals not to be proper in this context. That wasn't a felony murder jury instruction. That was the aiding and abetting, which was part of the state's theory. So it did confuse. And I just want to conclude briefly with Batson. I envisioned this as a very important case at this point in time in the state's history, and we haven't really had time to flesh it out. All I will say is this. It may be time for this court to reconsider and redefine exactly what Batson means. It is wholly inappropriate to lump all minorities together any longer and just say, well, some minorities as a group were stricken and some minorities were not. Okay? That is an insult to different minority groups. It assumes that they either vote alike or don't vote alike. That's not reality. The bottom line is Mr. Gonzalez is guaranteed a trial of his peers. There were Hispanic jurors stricken from this panel. And if you look at, and the court can do it, it's very simple because we've got the jury questionnaires. The reasons given in the record for striking the Hispanic jurors were inconsistent with the questionnaires of people who were kept. Whether they're black or white, they're not Hispanic. And so that is what I urge this court to consider and undertake. And with that, my time is concluded. I apologize for going a few seconds over. I believe there's reversible error in several respects, and I thank you for your time today.
Thank you, counsel. Are there other questions? Counsel, we thank both of you for your arguments today. We will take this matter under advisement. The court